Good morning, everybody. My name is Nigel George. I'm a solicitor and I'm also a director of Ageing with Optimism. And I'm here to talk to you about capacity and dementia this morning. The mind is a fascinating thing, isn't it? Apparently we've got something like 800 billion brain cells, I hear. My daughter, who is studying psychology, tells me that we men only use half our brain. Which is why, ladies, I'm afraid we only half listen to what you have to say. Similarly with words, that women apparently speak on average 2,500 words a day, and we men only speak 1,500. Which is why when we get home in the evenings and you go, "What have you been doing at work today, dear?" and we just grunt, it's not that we don't want to talk, it's just that we've run out of words until the following day. But the terms capacity and dementia, they're such sweeping terms, aren't they? And often heavily laden with very negative issues. If I were to say to you, I've got a physical health issue, you wouldn't be going, "Oh my God." Because if I say I've got a physical health issue, and it's not a term we use, it could mean I've got a paper cut, or it could mean I've just been hit by a truck. It covers a wide range of things, and equally, when you're talking about dementia or you're talking about mental capacity, you are covering a vast area of issues concerning both. Now, in terms of our attitudes towards mental health, they've changed over the years. When I was preparing for this, various things came to mind. The Lunacy Act of 1890, which established the Master of Lunacy. And he was the person who was in charge of mental health. And the Master of Lunacy continued until 1947, when we brought in the Court of Protection. You then got the Mental Deficiency Act of 1913, which gave us the wonderful moral imbecile. Anybody like to have a guess at what a moral imbecile might be? Well, it's, amongst other things, an unmarried woman. So, unmarried women, moral imbeciles. Thankfully, we've moved on a little bit from that today. Couple of key things to get across. We all have the presumption of mental capacity. I always find this encouraging when I wake up in the mornings that I am presumed to be sane. It doesn't necessarily continue very long during the day, but it's a good start to the morning. But it's a really important thing. If you take one thing away today, take away the presumption of capacity. Even if you've been diagnosed with dementia, there is still a presumption that you have mental capacity until somebody proves otherwise. You, the person who's been diagnosed with dementia, do not have to prove that you no longer have mental capacity. Somebody else has to prove it. Because when you're talking about mental capacity, it's mental capacity to do what? Is it mental capacity to get up? Is it mental capacity to cook? You may no longer have mental capacity to manage your finances on a day-to-day basis. Doesn't mean you can't make a will, and certainly doesn't mean that you can't make a lasting power of attorney. Dementia is often being described as a bit like Christmas tree lights, some flickering on and off, some going out altogether. Everybody's dementia is different. And we make many lasting powers of attorney for people who have got dementia. Yeah, it takes a lot longer. But one of the important things, and one of the important things behind the Mental Capacity Act, is it is there to empower people who have dementia. So, key thing, there is this presumption. And of course, the Alzheimer's slogan, "You can live well with dementia." Two of the key things when you're looking at the question of mental capacity is it is very much time and act specific. I may wake up in the morning and not be able to remember that I've got a dentist appointment that day. But as the morning goes on, as I become a little bit more awake, I've had a few coffees, I become aware that I have got a dentist appointment. And then I decide, well, I don't really want to go to the dentist because it'll hurt. Now, as long as I can understand the consequences of my actions, I am perfectly able to make those kind of decisions. Equally, if I have a heart condition and I'm unable to comprehend the fact that if I don't take my heart medication, I may well die, well, then someone else can make sure I take that medication. I'll give you a couple of examples of cases on this. A poor lady who had severe anorexia, but unfortunately that was coupled with body dysmorphia. For anybody who isn't familiar with what body dysmorphia is, it is you have a distorted view of your body image. You may be as thin as a rake, but you see yourself as being fat. Coupled with this, unfortunately, she had severe alcohol problems, which were so severe that effectively she had destroyed her liver. Now, the question was whether or not she should continue to be treated against her wishes. Remember, you can only be given medical treatment either with your consent, if you're able to give it, or without your consent if you lack capacity. But it has to be capacity for that particular issue. Now, in this case, they held that because of her body dysmorphia, she did not have the ability to make decisions about her anorexia. But so far as her alcohol problem was concerned, which comprised half a bottle of vodka a day, she was well aware of the fact that that was killing her, and therefore she was able to make decisions about her alcoholism. Another case, a poor lady who was a schizophrenic, who developed gangrene. Should she have her leg amputated? And the approach taken initially by the doctor treating her was, well, you've got schizophrenia. How can you possibly make decisions about whether or not you should have your leg amputated? And what the court said is, you're putting the cart in front of the horse there. You have to start from the presumption that somebody has mental capacity. You have to look at each decision individually. And in that case, they were not able to show that she didn't have the mental capacity to consider whether or not she should have her leg amputated. So, when you're looking at making decisions, and this is what mental capacity is all about, can you make decisions? It is a question of, can you take in the information? Can you rationalise that information, come to a decision, and then communicate that decision? Are you able to understand the consequences of your actions? And as long as you are able to understand the consequences of your actions, then you can make that particular decision. And you don't necessarily have to be able to retain that information for very long. You may have a conversation in the morning, at which stage you agree to some surgery or an operation, and come the afternoon, you may have forgotten all about it. Doesn't mean that you can't make that valid decision. Or alternatively, you may have said, well, I don't want the operation. Where a person has impaired capacity, they're not required to understand every piece of information. But in the same way that we don't, if our capacity is all right. You know, if someone is trying to explain a complicated medical procedure to you, most people wouldn't be able to understand it. If I try to explain in details the rules relating to mental capacity in the Mental Capacity Act, it would probably go over most people's heads whether or not they were suffering from a loss of mental capacity. One of the other things that you need to consider when you're looking at someone's mental capacity is you must not make assumptions merely because they are old, they appear dishevelled, they appear to be in something of a rambling state. You mustn't jump to unjustified assumptions. I think, as was mentioned before the break, the symptoms of dementia can appear in people who have other conditions, such as they've got a urine infection or a thyroid complaint, or they're just dehydrated. So it is important not to jump to assumptions. We're all entitled to be foolish. You don't need people's approbation. Word of the day for you. I don't need your approbation. And this means that you don't need the approval of the good, the wise, or the prudent. And that's a case which goes back to 1850 when it comes to the question of this. And the Act makes it clear that mere fact that you do something which might be a bit foolish doesn't mean that you are lacking mental capacity. Where there are question marks over somebody's capacity, you do need to go the extra mile in trying to communicate with them. We all have good times of the day when we're more receptive to discussions than others. If you want legal advice from me, don't come and ask me at 9:30 at night when I'm slumped in front of the TV. 6 o'clock in the morning, when I'm perky and awake, that's the time to come and speak to me. And we're all like that, and therefore, where you've got somebody who's got failing mental faculties, you've got to pick your time in terms of when you have these discussions. You've got to look at what visual aids you may need, and particularly with somebody who has dementia. Are you facing them on? Are you giving them time to talk? Are you sitting in an environment where there isn't a lot of background noise? These are important factors to take into account. And everyone's dementia is different. I mean, that's one of the key things that one needs to look at here. You can't just make blanket assumptions. Hospitals can be particularly stressful places for people with dementia. Anyone who's been following John's campaign in the press about, I think it's Nicky French or Nicky Gerard's father, who went from being able, confident, yes, he had dementia, but he was able to function still at quite a good level, and after 5 weeks in hospital came out very much a wreck of a person. I often tend to think that for a person with dementia going into hospital is a bit like taking a person with dementia to a disco, and then possibly giving them a tab of acid as well. They're not going to react well. But then, if we think any of us who are in hospital who've had an operation, are we at our best when people come to talk to us? And even less so where you're looking at with people with dementia. So, Mental Capacity Act is what this is all about. It's still one of the country's great secrets. Slowly people in the medical profession are becoming far more aware of it. Unfortunately, I think in terms of the general public, most of them have never heard of it. But it does contain some very important rights for all of us. Section 1, there is a presumption of capacity. Number 2, you must take every possible step to help people make decisions. Number 3, we're all entitled to be balmy if we want to. Number 4, any decision which is made must be made in our best interests. That is one of the most important aspects of the Act, best interests. And in fact, I'm going to mention the case in a moment, the whole issue of best interest is a growing area. And fifthly, if you're doing something, it must have the least restrictive effect upon me. Really important stuff. The Act is backed up by the Code of Practice, a mere 300 pages long. Anybody actually who's making a power of attorney says, or is an attorney under power of attorney says, I will comply with the Code of Practice, all 300 pages of it. But you can readily access it on the internet as you need, and clearly anybody who is involved in healthcare who doesn't comply with it does so very much at their peril. When we're talking about best interests, and best interest very much tends to come into play if you have reached the decision that somebody does not have mental capacity. And in those circumstances, if you're wanting to carry out any kind of medical treatment to somebody, this is only lawful provided you have established that they don't have the capacity for that particular treatment, and secondly, it is in their best interests. And as I say, the mere fact that someone has been diagnosed with schizophrenia doesn't mean that then gives you the right to lop off any of their bodily limbs if you feel that's in their best interests. You have to assess their ability on a case-by-case basis when it comes to carrying out any kind of treatment. We then get on to what do we mean by what's in someone's best interests. And again, it is important that you do not make assumptions because of someone's age or appearance or whatever. I mean, we live in a very multicultural country, and Suffolk increasingly is becoming far more multicultural. And multicultural not only in the way that you can judge people in terms of the colour of their skin, but often you may perhaps have an elderly person who doesn't appear to understand, and perhaps the reason they don't understand is that they're Ukrainian or they're Polish or their hearing aid has stopped working. And it is incredibly important that when you're looking to make decisions that you don't jump to conclusions. Are they going to recover their mental capacity in a reasonable period of time and be able to communicate with you? If it's something as simple as a battery to go in their hearing aid, well then yes, they are, before you start carrying out unwanted treatment to them. And one of the things that it says is that even if you have established that somebody doesn't have mental capacity, you must still try and get them to participate in any decision making. It also goes on to say you must consider their past and present wishes. And this whole question of considering somebody's wishes, even when they've not got mental capacity, is incredibly important. A few cases on this. The case of Aintree Hospital and James, where they looked at some depth at this whole business of what was in somebody's best interests. And they said, well, it's an elusive concept, what is in anybody's best interests. You need to look at somebody's welfare from a number of different perspectives. It's not only the medical care, it's also the sociological and physical perspectives. What are this person's values? What are their beliefs? Who has been consulted? Who has been spoken to? The Act makes it quite clear that you should try and speak to anybody who has an interest in somebody's condition before decisions are made. Which is why when I come across do not resuscitate forms and it just says, have you spoken to the patient or not, yes or no, there seems to be no reference to saying, well, have you tried speaking to anybody else in order to comply with the Act. And compliance with the Act is incredibly important. CQC make it quite clear that the Mental Capacity Act is the bedrock of good client care. It's something that I say to clients of mine if we've got in a situation where perhaps we can't put a power of attorney in place. If you're unhappy with the treatment that your friend or relative is getting, say to the nurse or the care home assistant, you're not complying with the Mental Capacity Act. How do you think that will sound on your next CQC report? It's not going to go down well. Something to make people think about. And it's a subjective test. There is no such thing as a reasonable patient. Think about it for a moment. Everyone sitting in this room today, we don't have an obligation to be reasonable. Is there such a thing as the Reasonable Persons Act, which says we must all be reasonable? If we want to be grumpy old buggers, we're perfectly entitled to do so. Now, why should we lose the ability to be grumpy just because our mental capacity is not fully functioning? We shouldn't. Everyone is entitled to be treated individually and have their views and wishes respected. A couple of very interesting cases. One in July considering a lady of some indeterminate age. By the way, I should mention, you've got some quite comprehensive notes from me which contains most of this stuff. There are a couple of typos, particularly in the additional single page that you've got. First case involved a Miss A.B., a lady of somewhat indeterminate age, but I think presumably 60 plus, had some history of mental health issues, had what seems to be the classic case of foot infections, which then go septic, which then become gangrenous and there's a need to have an amputation. But unfortunately, she had developed certain paranoid delusions so far as the medical staff was concerned, and was convinced that basically the reason that she had these problems was down to the medical staff, and that if she only allowed to go home, everything would be fine. Clearly, she didn't have mental capacity to appreciate her decision, and therefore the question was whether or not her leg, part of her leg, should be amputated. Now, was this going to be in her best interests? And one of the key things here was said, well look, if you do not amputate, this lady is going to die very soon. And this is normally the case in all of these situations where you've got septicemia. Either you amputate or someone is going to die from blood poisoning. But was this going to be in her best interests? And in fact, the only person who really spoke up and said it wasn't in her best interests was the independent medical health advocate, who said, have you considered what the implications are going to be for this woman if you cut off part of her leg? She is incredibly suspicious of medical authorities. Do you think her view of doctors is going to improve in any way if you go and cut her leg off without her consent? Do you really think she is going to be susceptible to taking part in rehabilitation from people who she sees are out to get her and has this daily reminder that they're out to get her because they've cut half of her leg off? Is she ever going to walk again if she's not going to participate in any form of rehabilitation? And it was said, yes, there was a real risk that she would react very badly. It would have a significant compounding effect on her mental health. She may never walk again and could have to spend the rest of her life in a high dependency mental health unit. So, question, was it really in her best interests to keep her alive in those circumstances? And the judge said finally, well, yes, I think keeping her alive is paramount in these circumstances. We then had another decision literally 2 days ago, and some of you may have heard about it on the news. This concerned a 73-year-old man, again, mental health issues, very isolated, again, needing an amputation, and he spoke out very strongly against it, and he said, I'm not afraid of dying, it will be better than the life that I have now. And the judge in this case, Peter Jackson, took the rather unusual step of actually going and seeing this chap and spending an hour with him to get a personal view of him. And the judge decided at the end of the day that it was not going to be in his best interests to keep this chap alive. And I'll just read you what he said. He said, I'm quite sure that it would not be in Mr. B's best interests to take away his little remaining independence and dignity in order to replace it with a future for which he understandably has no appetite, and which could only be achieved after a traumatic and uncertain struggle that he and no one else would have to endure. There is a difference between fighting on someone's behalf and just fighting them. Enforcing treatment in this case would surely be the latter. And what he then went on to say in connection with this was that once you have diagnosed somebody as not having capacity, that is not a light turning off moment where you can pretty much do whatever you like. But very much it is a question of looking at what is in somebody's best interest. And in terms of what they profess as their best interests is certainly something which must be taken into account. Not always, but if somebody is expressing their views clearly and stridently, those should not be ignored easily. And there's a growing tide. In fact, the Law Commission are looking at amending the definition of best interests, where it says that a person's wishes should be paramount unless there are some very strong reasons to the contrary. So This is quite groundbreaking stuff, because what we're saying here is we've established that people do not have capacity, i.e. they don't have the mental ability to make those decisions. However, notwithstanding that, their wishes must still be respected. And in fact, I mean, that's what the legislation is saying at the moment. We must still take people's wishes into account, but they're looking at very much beefing it up when it comes to this. So, and then finally, in connection with carrying out medical treatment, and somebody raised it earlier, and as I mentioned, that if you don't have capacity and it's in your best interests, medical treatment can be carried out, unless you have somebody who is a Court of Protection deputy or holds a health power of attorney who says, not so fast. The whole purpose behind a health power of attorney is for you to appoint somebody else to make health decisions on your behalf. They step into your shoes. And so long as they are acting in your best interests, they are perfectly entitled to turn around and say, do not carry out that medical treatment. And it's no good a doctor saying, I think it's in their best interests that I do this because it'll preserve their life. As an attorney, you're perfectly entitled, as long as you can show you're acting in their best interest, to say, no, you must not do that. And in fact, for a doctor to treat somebody when an attorney has legitimately refused that treatment would be a criminal act. It would be an assault. In the same way that you or I, if a doctor says, I'm going to treat you, and you go, I don't want to be treated, as long as you've got mental capacity, you are entitled to refuse that treatment, and if you are treated, that is an assault, that is a criminal offence that's being committed against you. And there's no real difference with an attorney doing that as well, as long as the attorney is acting in your best interest. I mean, I'll give you an example of what I mean by that. My wife is my attorney. If I fall down today, if I collapse on the kitchen floor today, and I'm bleeding, and she calls an ambulance and says to the ambulance people, well, actually, can you just get him off the floor because he's making a bit of a mess? I don't really want you taking him off to hospital. And they go, well, he's bleeding, you know, he could die. She goes, do I care? Now, in those circumstances, I've got his power of attorney, you know. I'm playing my joker card. Now, in those circumstances, you'd probably say she wasn't acting in my best interests. But say I'm 95. Say I've got quite advanced dementia. I've got liver failure. I've got multiple comorbidities. I have collapsed at home. I've made a written statement which makes it quite clear that I don't want to be bounced in and out of hospital at the end of my life. Ambulance turns up, I'm lying on the floor, I'm bleeding. My wife wants me moved, partly because she can't move me, and you know, I can't just be left on the floor, but she doesn't want me taken off to the hospital. I've made it clear I don't want to be taken off to the hospital. I just want to be placed in bed, I want to be cleaned up, I want to be pain-free. Now, can anybody say in those circumstances she's not acting in my best interests? And that's one of the things that increasingly I'm trying to get across to people. It is this whole business of planning ahead for things. And it's a bit like we don't plan ahead for funerals. It's a distress purchase. Nobody says when somebody dies, well, you know, we better shop around for an undertaker then, see what we can get, see what we can find on eBay. You tend to go to the first one. And similarly, if somebody collapses, you call an ambulance, it's the automatic reaction. But where you have got people who are at the end of their life, you should be continuing to do that. You know, there is this question of planning ahead, and I'll come on to that in a few minutes. So if you've got a power of attorney, your attorney can refuse medical treatment on your behalf. What are the other options open to you apart from powers of attorney? Well, as Louise mentioned before the break, you can make an advance decision. You can also get the Court of Protection involved, and that's a very expensive affair. There are end-of-life care plans, which you may discuss with your health provider or doctor at the time. There's also then consultation with family and friends that the doctor may have when somebody's approaching the end of their life. And then, of course, there are decisions which are made by medical and social services. The only person who can make decisions about your medical treatment is you. A spouse can't. And if you think about it, do we really want to live in a society where a spouse has a right to turn off our life support system? We hope that our spouse is always going to act in our best interests. But if they had a legal right to do that, they may not always be thinking in our best interests. So the only person who can make decisions is you. Doctors will listen to what family members have to say. They do not have to follow what those family members say. If you are a health professional and somebody says, I've got a power of attorney, I can make decisions. One of the first kind of things you've got to consider is, what kind of power of attorney is that? Because there are lots of different kinds. You can have a general power, you can have trustee powers, you can have enduring powers, you can have lasting powers, and then of course you've got Austin powers. Now, the only one of these that counts when it comes to medical decisions is a lasting power of attorney for health. So one of the simplest things to say to somebody, they say, I've got a power of attorney, ask when it was made. And if it was made before the 1st of October 2007, then it doesn't really count. Because that can only cover financial matters, can't cover your health. There are two separate and distinct ones, one for finances and one for health. Now, a lot of people are worried about signing powers of attorney because they view them as taking over control of their estate. But powers of attorney and attorneys have to comply with the Act. So remember, you have that presumption of capacity. Attorneys must always be acting in your best interests. These are important safeguards. A power of attorney is designed for your attorney to help you make decisions. It's not about them taking over when it comes to these kind of things. But it can cover any form of medical treatment or care. They are meant to act in your best interests. Now, what I now recommend to anybody who signs a health and welfare power of attorney is you make a statement of what you consider to be in your best interests. And so I had meant to, we've devised a template for this, which I had meant to put in your packs today. If anybody wants a copy of the template, my contact details are on the notes. Do get in touch with me. But it asks questions such as, what are your beliefs and values? What kind of medical treatment would you want and wouldn't you want? What other factors do you want taken into account? Because if you make a written statement, that's got to be had regard to. And the good thing about keeping it separate from your power of attorney is that you can change it over the years as your views change. Anything which goes into your power of attorney is rather written in stone. But you can change these things by way of a written statement. It's a totally separate document. It's often asked, do you need to go and see a lawyer to make a power of attorney? The answer is that you don't. But in a similar way as with a will, there are a number of issues to be considered, such as, do you appoint your attorneys jointly? Do you appoint them jointly and severally? How many attorneys do you appoint? Do you impose conditions? Do you impose restrictions? Lots of issues. And you only really get one chance to get these things right, because when at the time somebody is coming to use that power of attorney, it's normally when you've lost mental capacity, and it can be and obviously it's often too late at that stage to get a new power of attorney into place. And as was mentioned, the Court of Protection, if you have to go to them for help, that's very expensive and time consuming. Another useful thing that the Court of Protection can do are what are known as statutory wills. Sometimes people have no close family members. They may have made a will in favour of a dear friend who has then died, with the result that their estate would then perhaps go to some dim and distant relative on another continent. I mean, I've got cousins about 9 times removed in the USA. I mean, they are blood relatives, so, a long way distant, do I really want them to inherit my estate, or would I prefer friends of mine to do it? So, in certain circumstances where somebody doesn't have a will, or they had a will and beneficiaries have died, again, you can look at applying to the Court of Protection for someone to make a statutory will. One of the things you need to be conscious of is we've mentioned advanced decisions, we've mentioned powers of attorney, end-of-life care plans. You can have an awful lot of documents that you've signed about how you should be looked after, and there is clear room for conflict amongst these kind of things. So you do need to be careful, and again, if you're a health advisor, if you're discussing a care plan with somebody, it is important to establish, have you made a power of attorney? Have you made an advanced decision? Key thing in advanced decisions is, are you giving somebody the right to refuse life-sustaining treatment? Now, life-sustaining treatment is any form of medical treatment which keeps you alive. So that can be getting the crash cart and getting the old paddles out and katam in somebody's chest. Or it can be something as simple as a course of antibiotics. Any form of treatment which keeps somebody alive. In terms of whether you make an advanced decision or a welfare power of attorney, I tend to recommend to people that they make a welfare power of attorney. It's a far more flexible document, and it can be particularly helpful when you're dealing with people who have dementia. Remember, an advanced decision is merely saying, I don't want treatment X, Y, and Z. It's not allowing you to take an active part in somebody's health care, which a power of attorney can do. And often you may need to back up that power of attorney by getting the person to sign a form of consent that you can see medical records. Because remember, a health power of attorney only applies insofar as you don't have capacity to do that particular thing. So we take the example of the lady who had anorexia and alcohol problems. You've got a power of attorney, and the doctor says, well, I'm more than happy to discuss her bulimia with you, but I can't discuss her alcoholism with you. Because, she's got capacity, and therefore that will be confidential. So it's a good idea if you're having a health power of attorney that you also get a form of consent which confirms that you can discuss any aspect of somebody's medical care with them. Lastly, I just want to mention very briefly about dementia and people who are lesbian and gay. Channel 4 had a thing last year about elderly people going into care who were going back in the closet because they were worried about the reactions they would get. And in fact, a recent survey I heard that was done in connection with nursing homes, it asked nursing homes, I think in Suffolk, how many gay people they had in their nursing home, and an awful lot of them turned around and said, we don't have any gay people here. Clearly as you get older, you stop being gay and you all become straight. Stands to reason. But it was that people were concerned about prejudice. I was going to show a slide of John Inman, which had the thing talking about are you being served? Great programme, but get rid of the puff. And these were the prevailing views. And if you think particularly for somebody who is suffering from Alzheimer's, who is gay, he has lost his short-term memory, what may be one of the things he has forgotten all about? That it is no longer illegal to be a homosexual. Now, bad enough that you're losing your mind, but equally if you think that at any moment you could be arrested and sent to prison, it's not a good position to be in. We now have civil partnerships and same-sex marriages, but there's clearly a constituency out there of older people who have never necessarily acknowledged their relationships. I heard of one case of two elderly ladies in a village. They'd both been married and widowed in later life, been very close friends, One of them died in her 90s, and their friend who had been looking after her went and said to a doctor, I just want to tell somebody that this woman has been my lover. And she'd never told anybody that they'd had this lesbian relationship for 50 or 60 years. And often, and I've heard various care workers say that they perhaps visit a couple who they think may be gay, but having that conversation, oh, you know, this is a friend or my lodger. And you know, if you've concealed these things, it can be incredibly difficult to reveal those relationships. But this is where things like powers of attorney and wills can come in really useful. Because if you have an elderly gay couple, one of them has dementia, and the question is, well, is this a relative? You know, if that other person has a power of attorney, all they need to say is, I've got a power of attorney. End of conversation. You know, there need be no discussion over what the relationship is. I'm their attorney. Similarly with a will, I'm their executor. You know, and the law has moved on, and we have an awful lot of legislation which deals with the rights of unmarried couples. All of this legislation now applies equally to people who are in a gay relationship. So, Inheritance Family Independence Act, you've got an elderly gay couple living together. Only one person has the name on the title deeds, dies. Intestate, they're not married. On paper, the survivor has no claim against their estate, but they can bring an Inheritance Act claim. Or they could bring a constructive trust claim. There's a lot that can be done, and there's a lot of law out there that can protect people in these kind of circumstances. And finally, of course, the Equality Act. If people are subject to harassment in a nursing home, you know, what's a nice person like you doing being one of them? That is harassment under the Equality Act, and people can be prosecuted for those kind of things. So, thank you for listening. If anybody's got any questions, I'm happy to take them. But thank you very much.